The Honorable Supreme Court of the State of Illinois.
Mr. Marshall, the Supreme Court is reconvened.
Oyez, oyez, oyez. The Supreme Court is reconvened.
Before I call the first case this morning, on behalf of my colleagues and myself, I would like to thank you for your adaptability and cooperation in participating in our remote oral arguments this morning. The first case on the call of the docket is agenda number 9, number 124863, Matt Sharp et al. Versus Crystal Westmoreland, Appellee. Mr. Scodro, you may proceed.
Thank you. May it please the court, counsel. I'm Michael Scodro on behalf of the appellant, Chris Fulkerson. Your Honors, the General Assembly could not have been clearer that the Civil Union Act is intended to create rights and obligations for civil union partners that are equal in all respects to those of married spouses. The very first substantive provision in the Civil Union Act makes this clear in asking the reader to liberally construe the act to promote the General Assembly's express aim of providing persons entering into a civil union with the obligations, responsibilities, protections, and benefits afforded or recognized by the law of Illinois to spouses. The act then proceeds to operationalize that express objective in two ways, and it does so in a manner that avoids the need for the General Assembly to independently amend what one senator on the floor of the Senate estimated at 650 rights that were being afforded civil union partners through this equalization of civil unions and marriages. It does so first with the definition. The statute provides that a party to a civil union means and shall be included in any definition or use of the term spouse, family, immediate family, dependent, next of kin, and then the catch-all and other terms that denote the spousal relationship. And then broadly, that phrase ends as those terms are used throughout the law. Just two provisions later, the same point is made by when the statute in section 20 provides that a party to a civil union is entitled to the same legal obligations, responsibilities, protections, and benefits as are afforded or recognized by the law of Illinois to spouses. And then it goes on in the broadest possible terms, whether they derive from statute, administrative rule, policy, common law, or any other source of civil or criminal law. One is hard pressed to conceive of a phraseology or a construct that would more clearly or more broadly impute civil union and civil union partners into every instance in Illinois law where marriage or spouse then existed. With that as background, Your Honors, we then turn to the Marriage Act. And in relevant part, the appellant in this case seeking standing in order to seek an allocation of parental responsibilities and child visitation. And those provisions provide that a step-parent has standing to seek these rights and define step-parent twice identically as a person married to a child's parent, including a person married to the child's parent immediately prior to the parent's death. There's no dispute in this case that Ms. Fulkerson was married to the child's parent, or not married, was engaged in a civil union, was a partner in a civil union with the child's parent. And the only question is whether the term married denotes a spousal relationship within the meaning of Section 10 of the Civil Union Act, such that it includes now, by virtue of the Civil Union Act, includes the notion of a civil union partnership. And there can be no question but that the term married denotes the spousal relationship that is talked about in Section 10 of the Civil Union Act. And indeed, were there any doubt, as we point out in our brief, there is a long string of statutory construction provisions that support this reading, not the least of which is the longstanding canon that two provisions are to be read in harmony in a manner that avoids inoperative language, inoperative provisions. Well, undoubtedly, the appellant's contrary reading here would not only defy the plain meaning of the three sections of the Civil Union Act that I've mentioned, but it would also have the effect of effectively rendering them inoperative, certainly inoperative in their full and stated extent. Beyond this, we have legislative history that is perfectly consistent and indeed supports this broad reading. As we point out on pages 16 and 17 of our opening brief, Your Honors, in both chambers, members of the Illinois General Assembly spoke not only broadly in terms of equalizing the rights, making an equivalency between the rights of civil union partners and married spouses, but at the same time also spoke more specifically about family and about children as part of that equalization. Finally, Your Honors, with regard to the affirmative points in favor of this being the only available reading of these two statutes in combination is the doctrine of constitutional avoidance. There is no question but that the contrary reading, one that treats civil union partners and married spouses in this context, would run afoul of the federal and state equal protection clause. Those clauses would demand a rational basis for distinguishing between the partner to a civil union with a biological parent of the child they're raising and a spouse in marriage to an individual who is the biological parent of the child.
Counsel, why then didn't the General Assembly, when they overhauled the statute, the act in 2015, why didn't they specifically include this?
Your Honor, it is true that there have been a couple of amendments that are talked about in the briefs to the Marriage Act that at times the General Assembly has added specific reference to civil unions. But a couple of points in response to that, Your Honor. First, given the backdrop that we've just discussed, there is certainly no need for the General Assembly to do that at any point throughout the code. And I could point out other examples. For example, the Probate Act, which uses the word spouse and doesn't at any point mention civil unions, but undoubtedly we would all agree is intended to also capture the rights of civil union partners. But to more directly answer Your Honor's question, to be sure, there are places in the Marriage Act and elsewhere where the General Assembly has on occasion in the course of amending made crystal clear, made express what is already true by virtue of the Civil Union Act. And one can imagine all manner of reasons why under a particular circumstance they would be moved to make clear to avoid any ambiguity, for example, but there isn't any by virtue of the Civil Union Act. And one can point to other places, Your Honor, in the Marriage Act, for example, where the term spouse is used, but we would all agree, notwithstanding the amendments that have added civil union elsewhere, spouse alone is used, but undoubtedly includes both. I would direct Your Honor to sections 401 through 413, which involve the dissolution of marriage. Section 45 of the Civil Union Act makes clear that those provisions apply equally to civil union partners, and yet the word spouse alone is still used in those provisions. So I think there can be no doubt that while on occasion the General Assembly has seen fit to add the term civil union in the course of another amendment, the fact remains this cannot be viewed as a silent effort to take away the background principle that could not be more clearly established, Your Honor, in sections 5, 10, and 20 of the Civil Union Act. And it's far more reasonable to assume that they were simply making express what was already true in those provisions than to assume that by adding those references to civil union, they were impliedly withdrawing what had been equality that applied across the board in the act before that, Your Honor.
Counsel, can I ask you, is the definition of step parent in the Marriage Act standing alone ambiguous?
Your Honor, we don't believe it's ambiguous. Standing alone?
Well, I mean, yes, that statute, that provision, that definition standing alone.
Given the civil union backdrop, Your Honor, it is unambiguous. The background principle, in the same manner that other statutes may inform that provide rules for construing other statutes, It is not ambiguous, Your Honor.
Isn't it true, though, that reading a statute in pari materia is a technique of statutory interpretation used only when a statute is ambiguous? If it's not ambiguous, if it's unambiguous on its face, we don't resort to these tools.
Thank you, Your Honor. To be clear, the use of these canons of construction are merely, in our view, further supportive. But in light of the unambiguous language of the Civil Union Act, which is telling the reader, look, add in the phrase civil union every time there is anything in any of the hundreds of places in the code where there is a reference to quote unquote spousal relationships. And just as I think even the Appellee would agree that that is certainly what's happening in the Probate Act, where we would all agree that is something that undoubtedly was intended, even though only the word spouse is used there, a marriage-specific term. The same goes here. We don't think the court needs to get to legislative history or necessarily needs to consult these canons, though I would note that when you have two statutes that are both addressing the same topic, even though you're sticking with the face of the statute, it is not uncommon for courts to consult in pari materia and other such doctrines. That's not diving below the surface of the text. It's simply recognizing that the same phrase appears in multiple places, Your Honor. I would move on briefly, if I may, to discuss the reasons advanced by the lower court and to some extent in the brief of the Appellee in favor of the contrary reading, in favor of the reading that would roll back the equivalency provided by sections 5, 10, and 20 of the Civil Union Act. And the first reason advanced is that there is an exception, an unstated exception for certain cases involving children. And that as broad as the language may be in sections 5, 10, and 20 of the Civil Union Act, in fact, this was intended to contemplate a carve-out for certain cases involving children. Well, the answer to that is the plain text answer. Obviously, sections 5 and 10 and 20 of the Civil Union Act do not permit any exception. Again, the idea here, and this goes back to Your Honor's question regarding in pari materia and reading these in isolation, the idea here on the face of the Civil Union Act could not have been more express. They are saying, we are not going to go through as a General Assembly. We may at times make this express to make it crystal clear for whatever reason may motivate under those circumstances, but we are not going to go through and change every instance in which a phrase like marriage or spouse appears in Illinois law. But going forward, those terms include, by operation of law, those terms now include a reference to civil unions. So again, the notion that there was some holdback envisioned at the time is not only inconsistent with the plain language, most importantly, but would be inconsistent with the legislative history at the time. Again, though, Your Honor, no need to reach it given the clarity of the General Assembly's statements. So this court is being asked, contrary to its repeated decisions, it's being asked to read an exception into the statute that simply doesn't appear on its face. The second reason offered by the Appellee is the idea that unless this court were to recognize some lack of legal equivalency between civil unions and marriages, then the two would be essentially redundant statutes and this would be confusing. Well, there are a couple of answers to that. The first is that isn't grounds for a judicial rewrite of either statute in order to find some way in which they're simply asymmetric. There's some way in which they're different. But more importantly, or perhaps on these facts more importantly, that isn't actually the case. As we point out in the briefs, the federal government is not under an obligation to see the two as equivalent in all respects, even though they are under Illinois law. And indeed, this federal government doesn't view them as identical in all respects, even though they are under Illinois law. Moreover, as we point out in our reply brief, it's easy to imagine that simply the difference of terminology matters, and that for some people, as a matter of history, sociology, religion, politics, there may be a perceived difference in the notion of entering into a civil union as opposed to a marriage. That does nothing to undermine the fact that the General Assembly intended and expressly intended to make them equivalent as a matter of rights and obligations. And finally, and we've discussed, in response to Justice Garmon's question, we have discussed the 2016, 17, and 18 amendments. And again, I would just highlight the fact that nothing about those amendments implies that the General Assembly was silently withdrawing rights that it had conferred through the Marriage Act in 2011 by saying that wherever anything involving spousal relationship is involved, it now involves civil unions. But again, there would be anomalies remaining not only in that act, including the 400 series that I mentioned, where there's an absence where they haven't made that change, but taken to its logical conclusion, that theory would mean more broadly that having conferred these rights wholesale in 2011 very expressly by in certain places in the code referring to civil unions expressly, they have taken it back as to all the other places in the code where currently we're relying solely on the word spouse or marriage. As I said, that includes the probate code among others. And so that such a decision that was the implicit conclusion of the General Assembly and the intent not only defies plain language, we would expect far more from them to override something they made so clear, but it would have sweeping ramifications throughout the Illinois Code. The final point I would like to address, Your Honor, there is some mention both in the lower court opinion and also in the briefing of the Appellee regarding the superior rights doctrine. And I just want to make clear, so there's no confusion, this case, nothing about what is being discussed or nothing about what the court is being asked to resolve in this case implicates the superior rights doctrine. This is the notion that biological and or adoptive parents, by virtue of the Due Process Clause, enjoy certain superior rights with regard to decision-making in connection with their children. Those rights are soundly protected, and I don't believe that Appellee disagrees. Those rights are squarely protected by the very provisions we're talking about, 601.2, 602.9. Just at the standing phase, those statutes create hurdles and hoops for the non-biological, non-adoptive parent to go through merely to obtain standing to seek visitation or to seek an allocation of parental responsibility. And so the notion, I don't think there's disagreement that there's anything about the statute and the scheme that it creates that in any way imposes upon or is out of step with Troxel, which is the Supreme Court decision on this, as well recognized since 2009 in this court's decision in Wickham. None of that is disputed. The question before the court is whether a provision that on its face allows for certain non-biological, non-adoptive parents, namely step-parents, whether in construing that term, a civil union partner is treated and put on the same footing, that is given the opportunity to go through those hoops, to circumvent those hurdles and to obtain standing, is put on the same footing as the married spouse, as the Civil Union Act makes clear. And none of that in any way implicates the superior rights doctrine that's discussed at times, again, in the lower court and in Appellee's brief. Unless the court has further questions.
Seeing none, all right.
Thank you, Your Honor.
Ms. Shearer? Could you turn off, put your mic unmuted? Unmute your mic. Microphone? Unmute your microphone.
I got it. I apologize. Thank you.
It's all right, go ahead.
This is new to all of us, I think.
Yes.
May it please the court and Chief Justice Burke. I am Barbara Scherer and I represent the appellee Crystal Westmoreland, the mother of the minor child that we are talking about here. My client is asking this court to affirm the decision of the Illinois Court of Appeals for the 5th District and deny the civil union partner Chris Fulkerson, standing to infringe upon her rights to make decisions about how her child is essentially raised. Revisiting the civil rights doctrine that Mr. Scadro was talking about, we are talking about the superior rights doctrine. I apologize, I misspoke. One of the most paramount fundamental rights that Illinoisans and actually all United States citizens have, pardon me, is the right to make decisions about our children, who they spend time with, how they're raised, what they do, and that they be raised and we make decisions free of the government entering our living room unless there's some indication that the parent is not fit or that the child is in danger. With very narrow exceptions, Illinois, and in fact, the United States Supreme Court has indicated that it is now left to the states in Troxell versus Granville to carve out exceptions when a non-parent has the right to intervene and either ask for time or decision-making to raise or to partake in decisions regarding a child that is either not their own biologically, or I guess in these cases by IVF or surrogacy or by adoption. And that's not the case here. The Illinois legislature has been very, very specific, including in 2016 when they modified provisions 750 ILCS 600 and related provisions to define individuals who had standing to ask for parental rights, essentially visitation, parenting time, or parental allocation of responsibility in the fourth spheres of influence. They revised that in 2016. It was after the Civil Union Act came into effect in 2011. It was after the ratification of same-sex marriage in 2014. And it was after, I believe it was midway through 2015, where we had a United States Supreme Court case that essentially said, it doesn't matter if you're the same sex or not, you can get married anywhere in the United States. It is hard to believe that the legislature of the state of Illinois made specific modifications to the Civil Union Act. And Mr. Scadro indicated they began in 2016. That's not accurate. They began in 2015 when we had a major overhaul to maintenance. Perhaps the biggest major overhaul to the Illinois Marriage and Dissolution of Marriage Act did happen in 2016. July 1st, 2017 saw the way child support was calculated changed. We've had a few changes regarding maintenance. We upped the statute from $250,000 to $500,000 a year for combined gross income. We've had other changes. The Civil Union Act was on the legislature's radar. They made specific changes within the Illinois Marriage and Dissolution of Marriage Act, which I apologize, I refer to it as the IMDMA just because we talk about it all the time. They made changes. They included specific modifications that incorporated the Civil Union Act. Why would they do that? Why would they put that language in there if they intended that the Civil Union Act just applied? Also, I don't know any other place in the state of Illinois where we have two laws or two statutes that do the exact same thing. Ms. Fulkerson, the civil union partner, is asking this court to say that the Civil Union Act, which I call the CUA, and the IMDMA do the exact same thing. It is true. They are different ways to ratify, formalize, or do a lifetime commitment ceremony to indicate, hey, I'm spending the rest of my life with this person, much like a marriage has done for thousands and thousands of years, both religious.
Don't both define the partner as a spouse, the Civil Union Act and the Marriage Act?
They do, but they're not inconsistent. Here's the, if I may elaborate on with an answer to your question beyond yes, Justice Burke. They do both say that well, obviously, if you're married, you're considered a spouse. I mean, that one we know. The Civil Union Act equates civil union partners as if they have the same rights as spouses, but here's the difference. They equate civil union partners as if their spouses vis-a-vis or relative to one another. And Mr. Scadro mentions the Probate Act, and frankly, I think that's a perfect example. Under the Probate Act, if a civil union partner is not included in their civil union partner's will, they have the right to take the spousal election of one half. But there's nothing in the Civil Union Act itself that talks about it having the overarching effect where it reaches into the other civil union partner's relationship with a child, not of the civil union. And in fact, one of the amendments to the IMDMA indicates that children who are the product of a civil union, either by natural birth, adoption, or I presume if they're the same sex, if they hire a surrogate or they have IVF or a donor, be it anonymous or not, that children who are the product of a civil union are considered children of the civil union, much like the Marriage Act indicates that children who are born during a marriage, whether or not a parent is having a relationship outside the marriage, they're considered a product of the marriage. I'm presuming this was done so if children are born during a civil union, you don't have to file what we call an
Under that situation, though, the spouse is considered a step parent, isn't it?
No, they're not. They're considered. I'm sorry. Let me.
If it is not the biological child of one of the spouses, they could be considered a step parent.
No. I mean, the act does not address that. I mean, no, it absolutely does not. It indicates that children who are the product of a civil union are considered, I hate to use the word legitimized because it just brings out some antiquated terms that I really prefer not to use. But what it indicates is that children who are born during a civil union are considered children of the civil union. So we have either mommy and mommy, daddy and daddy, or
But in
mommy
this situation, one of the biological parent just died. And, right?
Are you asking me if you have children that are born during a civil union and the person who if they're not a
If it's
heterosexual?
someone else, if the two and one had a child, the spouse is a step parent to that child.
No, the child is considered legitimate, a child that's a product of the civil union, much like if you have, let me use this example. Say you have a married heterosexual couple and the woman obviously is the one who's going to get pregnant and carries a child and the father dies. The child is still, and even if the child was born to, because the female had an extramarital relationship, the child is still considered a product of the marriage. So
So that's
mother,
not what I meant, but if the biological child of one spouse
spouse or civil union partner.
could, yes, and that person gets married, so the child of the biological mother is her partner, the new spouse, is the step parent of that child.
I'm sorry, there's a little bit of a delay with the Zoom and you cut out a little bit. I want to make sure I understand your question, Chief Justice.
If
Burke.
two people get
So
married,
you're
whether
saying,
they be heterosexual or same sex, and when they get married,
correct.
one of them had a biological child with someone else.
Okay.
So the new spouse is the step parent to that child. Is that not right?
Absolutely.
That's what I was asking you.
I am sorry. There's a cut out. There's a cut in the Zoom.
Okay.
I apologize.
Okay.
So I'm sorry, I can't
All
hear
right,
you.
go ahead with your
Okay.
Could I go back to the statute? Could you, Mr. Scoto argues that the statute is crystal clear. So I'd like you to go back and engage the language of the statute that we're talking about. The statute that says a party to a civil union is entitled to the same legal obligations, responsibilities, protections, and benefits as are afforded or recognized by law of Illinois to spouses. And then earlier, defining what that means, the statute says a party to the civil union means a person who has established a civil union, and party to a civil union means and shall be included in any definition or use of the term spouse, family, immediate family, dependent, next of kin, and other terms that denote spousal relationships as those terms are used throughout the law. Mr. Scoto
Yes.
says pretty clear language intent of the legislature that in other areas of the law, whether it's in the Marriage Act or the Probate Act or elsewhere, that the term spouse or spousal relationship would mean the same thing as a party to a civil union. Why is that not a clear directive from the legislature?
I can tell you why. Because first of all, we're not talking about the Civil Union Act here. This action was filed under the Illinois Marriage and Dissolution of Marriage Act, probably because there's nothing in the Civil Union Act that gives a civil union partner rights over a child that is not their own naturally or not a product of the civil union. And Ms. Fulkerson tries to focus everything in her brief, in their argument on the Civil Union Act. This case is not about the Civil Union Act. It's about the Illinois Marriage and Dissolution of Marriage Act. There's a very narrow definition of step-parent. It's defined as married to. In fact, the only place in the Civil Union Act where there's mention of anything that denotes a relationship with a child, say custody, child, or parent, is in the provisions of the Civil Union Act that are, I would call them, I guess, more administrative or clerical. When you're applying for a license to become a partner or party to a civil union, you have to list your own parents' pedigree information. There's nothing in the legislative history of the Civil Union Act or the IMDMA that indicates that there was an intent that the Civil Union Act had the overarching effect of having you reach into having parental rights or responsibilities, for that matter, over a child that was not either your own naturally or a child that was the product of a civil union. And I think the IMDMA tells us that, because if you look at all the amendments that have been made to the IMDMA beginning in 2015, none of them indicate that there are any rights or responsibilities to children who your civil union partner may be the natural parent of, unless they were born during the civil union.
Could you go
support would
back
be
to the language, of the Civil Union Act? That, again, trying to define what obligations and rights a partner to the civil union have. The statute says party to a civil union means and shall be included in any definition or use of the term spouse or spousal relationship as those terms are used throughout the law. Doesn't just say in the Civil Union Act. It says throughout the law. That this appears to give us a definition of what those terms mean throughout the law. No?
I'm sorry, there's a delay. I just wanted to make sure you were speaking. So my answer would be this, Justice Tice. First of all, this is not about the Civil Union Act. We're interpreting the IMDMA. We are looking at the superior rights doctrine. Had the IMDMA not had any amendments to it that included the word civil union or the term civil union or reference to the Civil Union Act, since the Civil Union Act was passed in 2011, I think it would be a different story. But the fact that they include it in the IMDMA in some provisions and not in other is an indication that the legislative intent was not to include the right for civil union partners to have rights and or responsibilities, benefits or obligations to a civil union partner's children that are from another relationship. So I don't think the acts are inconsistent to read them the way my client is proposing. Spouses under the Civil Union Act have rights relative to one another. And if you look at the legislative history of the Civil Union Act, there is no discussion about having rights to children who are your civil union partners from, let's just say, another relationship. There's nothing about that. The Illinois Marriage and Dissolution of Marriage Act, if you look at that legislative history, and if you also look at a line of both Illinois and US Supreme Court cases, indicate that it is with very, very narrow exception that we give non-parents decision-making rights or visitation rights to interfere or to infringe upon a natural parent's or an adoptive parent's rights to make decisions about their children. So I think you can read the Civil Union Act and the IMDMA the way I'm proposing, and they're not inconsistent. If these laws, if the IMDMA and the Civil Union Act were intended to do the exact same thing, why have them? We don't need both, especially with the ratification of same-sex marriage in 2014, and especially after the United States Supreme Court indicated that all states needed to allow sex marriage. I believe it was in June of 2015, but I may be wrong on that specific date. There would be no reason to have the Civil Union Act and the Illinois Marriage and Dissolution of Marriage Act if they did the exact same thing. The point is they don't do the exact same thing.
Is this couple heterosexual?
I'm sorry?
Couple, Are they heterosexual? Are they same sex?
Are Chris Fulkerson and Matt Sharp man and woman? Is that what
Yes.
you're asking me? I'm sorry, there's such a delay here. Okay, Matt
Yeah.
Sharp is a man, was a man, he has passed away, unfortunately. Chris Fulkerson is a woman. And so there was no impediment at any time to them getting married. And I might also add that this civil union between Matt and Chris was entered into less than 2 months before Illinois ratified same-sex marriage. So even if they were both men or both women, they could have easily not only married as of, I guess, January 1st, 2014, but the Civil Union Act provided basically a grace period of 1 year after same-sex marriage was ratified in Illinois to convert your civil union into a marriage. Additionally, there was a period of time prior to Matt Sharp's death where everybody knew that he had a very aggressive disease, and they could have gotten married then. I would say this, that a misunderstanding of the law, a misreading of the law, even getting an incorrect legal opinion from an attorney, or ignorance to the law, or having a tragic situation is not a basis to ask any court for relief, or it's not a reason to rewrite the law. Chris Fulkerson chose to avail herself of a civil union, and that's a fine choice. We don't need to get into why she decided to do that, but it doesn't give her every single right or ability. It certainly doesn't give her standing. She is not married, was not married to Matt Sharp pursuant to the terms of the IMDMA. The legislature has been left pursuant to Troxel versus Grandel to make decisions about what non-parents are going to have standing. Once you go down that slippery slope of reading into the statute and by saying, and it's tempting to say, hey, she was another adult, she probably had a relationship where she was essentially, for lack of a better term, parenting this child or acting in the role of a step-parent. That's for the legislature to decide. They decided to not accord that. And once we start going down that slippery slope, what are we going to do? What happens to other, say, adult responsible individuals who might have developed a relationship with a child? Think about the situation where you have either one or two full-time working parents who hire essentially a full-time nanny. We see that all the time. We've seen it in the movie The Help. We've seen where these nannies develop a closer relationship with a child than their own natural or adoptive parents. Are we going to start giving them rights to come in and ask for parenting time? Absolutely not. That's why Troxel versus Granville was determined to be constitutionally essentially vague and overbroad, and why they left it to the states to legislate what non-parent individuals are going to have standing to then jump through a several-pronged test to decide whether or not they would have input either in terms of time or decision-making in the 4 spheres of influence with children that were not their own, either naturally or through adoption. And I'm sorry, the situation is tragic, but Chris Fulkerson just does not meet the muster of the test under the IMDMA. If there's nothing further, I would be ready to conclude my argument.
All right, thank you. Any more questions? Seeing none. Mr. Scodro.
Thank you, Your Honor. I'd like to address a few of the points that were just raised in the response portion of the argument. First of all, this is as straightforward as Justice Tice indicated with her question. This is the language that's used here is as if the General Assembly had passed a law that said, look, we recognize that sometimes we use he, sometimes we use she in our statutes, but either one means he and or she going forward. We don't actually intend to draw a distinction. And that's what they've done here. They've said every time this is used, and there's nothing on the face of these provisions that purports to limit them to any one type of case, child, non-child. There can be no doubt that the right to at least go through the many hoops that a non-biological parent has to go through to get standing, even to seek some form of visitation or allocation of parental responsibility. There's no question that that is a benefit or a right as those terms are used in the Civil Union Act. And so the fact that at times, and Ms. Scheer actually used the phrase that the Civil Union Act was on radar in 2015, 16, 17, 18, when other changes were made to the to the Marriage Act. Well, that's dispositive. Of course, it's presumed that it was on radar, just as it would be presumed that a law that says he means he or she and she means he or she, even if at times the General Assembly might include the phrase he or she expressly, at one point, that is not intended to mean that every other place in the code now, it means he when it says he only, or she when it says she only. This is what they clearly intended to do. And the fact is, and this goes back to the impari materia question from Justice Burke at the outset, impari materia, all statutes are read together in the first instance. And if then ambiguity is created by the reading in combination, you would turn to methods of construction. But under these circumstances, it's quite clear that the statute has said, whenever these terms appear, marriage, spouse, anything of that nature, it is to include civil unions. And the fact that at times they say the equivalent of he or she, the times they say they add this phrase in, can't mean, and this is what I understand to be the implication, it can't mean that in 2011, let's just take the Marriage Act. In 2011, the Civil Union Act applied to the Marriage Act exactly as it says it would. Every time, any phrase is used that refers to marriage or spouse, it includes civil union partners. But starting in 2015 and going through 2016, 17, at that point, by including this additional phrase at times, unnecessary but made express, that the phrase it's marriage or civil union, for example, that at that point the General Assembly has silently now revoked rights originally conferred upon civil union couples in 2011. I just think that cannot be the case. We would expect the General Assembly to make such an intent clear. Now, there was a question about how can we have two parallel statutes. I think we've addressed that. The history, of course, explains how this came to pass, that there wasn't a recognition of same-sex marriage in the state of Illinois in 2011 when the Civil Union Act was passed. And indeed, that is why there was so much attention focused on the fact that every right and responsibility of a married couple was being conferred upon the partners to a civil union. It would have come as a great surprise to reading the legislative history, though, again, we don't need to, but if you were to, it would come as a great surprise to the members of the General Assembly that they weren't actually creating a situation that was fully equal, an institution that was fully equal, including on the paramount issue of childcare, visitation, and parental responsibilities. That would have come as a great surprise to those involved in 2011. Nor can it be the case that having granted those rights in 2011, the fact that same-sex marriage becomes legal in Illinois in 2014 somehow changes and withdraws those rights that had once already been conferred in 2011. I do want to talk briefly about the notion that Ms. Fulkerson and her civil union partner opted for a civil union. This is precisely what the language of the Civil Union Act is intended to avoid, namely the notion, and think about this in 2011 when this was passed, where the choice didn't exist. It doesn't matter that there's a choice that you can do one or the other. As noted, the two terms have different connotations. One can imagine reasons in name alone why someone even today may choose civil union versus marriage. And as I've mentioned, there are federal law differences that apply to the two. So they are not equal in the eyes of the federal government, even though they are absolutely equal under Illinois law. But if anything, the fact that Section 65 of the Civil Union Act, which is the provision that I believe counsel was referring to, which is provided a one-year window during which you could change the nature of your civil union into a marriage cost-free, the very fact that that was provided suggests that something as fun, that these were seen in the eyes of the General Assembly as entirely equal. If they weren't, would the General Assembly have provided this easy method to change from one name to the other? No, they did it because they recognized that these are two scenarios with equal legal rights. And therefore, if someone, by virtue of the federal differences, by virtue of the name and the connotations, sought to change, they were free to do so. saying that that this provision of the Marriage Act doesn't include the phrase civil union is tantamount to saying that same phrase in the Probate Act uses the word spouse and not civil union partner. So when counsel notes that there's no use of the word civil union in the definition of step-parent, that is tantamount to saying that the Probate Act doesn't say anything other than spouse. And as we've discussed, there's no dispute that in those circumstances, the background principles set in motion by the Civil Union Act make spouse include civil union partner. And indeed, there is nothing about the Civil Union Act, reading those phrases we've talked about, there's nothing on the face of the act that distinguishes between relationships between the two spouses versus children of one of the two spouses. And the notion that that ought to have been specifically discussed on the floor of the House or the Senate. There was comment made that the legislative history doesn't make particular reference to that kind of child relationship. Well, that's not surprising at all. As one of the senators noted, there are some 650 rights that were being incorporated wholesale into the notion of a civil union by the stroke of a pen in passing the Civil Union Act. And so it is completely unsurprising and natural that there wasn't specific discussion of all 650 of those rights, including particular circumstances involving child visitation, where the child was the biological or adoptive child of one of the two members to the civil union. So there's nothing about legislative history, omissions or commissions, that would suggest that would in any way support the Appellee's reading here. Just checking my notes to make sure there's nothing additional, but unless there are questions from the court. Oh, and I should just add, this is not opening the door to some sort of landslide. Again, Appellee has already made the point that one could easily switch from a civil union to a marriage. Well, isn't that proof positive that by including both, as the legislature clearly intended in the definition of step-parent, that doesn't have any constitutional implications under the superior rights doctrine? If one can switch that readily, then there can't be a legitimate argument made that including both in the definition of step-parent somehow blows the door wide, nor is there a statute that says that the term full-time caregiver will receive, that a full-time caregiver should receive all the rights and duties and obligations of a parent. And so under those circumstances too, the notion of the parade of horribles is simply not in play, Your Honor.
Thank you, Mr. Scodro. Case number 124863, Matt Sharp et al. Versus Crystal Westmoreland Appellee is taken under advisement as agenda number 9. Thank you, Ms. Scher and Mr. Scodro, for your arguments this morning.
Thank you.